South Africa's ambitious plan to overhaul its healthcare system is now facing a critical moment of truth as the national health insurance policy becomes increasingly entangled in a growing legal storm that is not only delaying its implementation but also costing taxpayers millions, raising serious questions about whether the government underestimated the scale of resistance and the complexity of the reform. At the center of this unfolding crisis is Aaron Motsoaledi, who has revealed that the government has already set aside approximately 74 million rand to defend the National Health Insurance Act in court, a staggering figure that highlights just how intense and widespread the legal pushback has become, with at least 15 separate cases currently challenging the policy from multiple angles. These legal challenges are not minor technical disputes. They strike at the very foundation of the policy because they question everything from how the law was adopted to whether it is constitutionally valid in its current form. And that is where the real problem begins. The Constitutional Court of South Africa is now preparing to hear key cases that could ultimately determine the future of the NHI, with hearings scheduled to address critical concerns around public participation, legal procedure, and constitutional compliance, issues that have already forced the government to pause parts of the policy's implementation. This pause is not just symbolic, it is a clear signal that the legal risks are serious enough to halt progress on what was once described as one of the most transformative policies in post-apartheid South Africa. And that raises a difficult question. Was the policy rushed? Because evidence suggests that the government may have pushed forward with the legislation despite clear warnings that it would face significant legal opposition, with multiple organizations, including healthcare groups, provincial governments, and civil society bodies, stepping forward to challenge the law in court. What makes this situation even more concerning is that while millions are being spent defending the policy, there is still no clear, sustainable funding model for the NHI itself, with analysts pointing out that the broader healthcare system continues to face immediate financial and structural pressures that remain unresolved. This creates a paradox, because while the government is investing heavily in defending the idea of the NHI, the practical reality of how it will be funded and implemented remains uncertain, and uncertainty is costly, not just financially, but politically. The legal battle itself has now become a defining feature of the NHI rollout, with the policy effectively shifting from a legislative process into what many analysts are calling a courtroom war, where its future will be decided not by policymakers but by judges weighing complex constitutional arguments. This is a dangerous place for any major reform to be, because once a policy enters the legal arena at this scale, control over its direction begins to shift away from government and into the judiciary, and outcomes become far less predictable. At the same time, the political stakes are rising because the NHI was positioned as a cornerstone policy aimed at addressing inequality in healthcare and expanding access to millions of South Africans, meaning that any failure or delay could have significant implications for public trust and political credibility. Yet critics argue that the current situation reflects deeper issues in governance, particularly the tendency to prioritize ambitious policy announcements over practical implementation planning, a pattern that has been observed in other sectors where large-scale reforms have struggled to move beyond the planning phase. Supporters of the NHI continue to defend the policy as necessary and transformative, arguing that resistance from private healthcare interests and other stakeholders is part of a broader effort to protect existing systems that benefit a limited portion of the population, highlighting the ideological divide that continues to shape the debate. But even within that debate, one reality is becoming increasingly difficult to ignore. The longer the legal battles continue, the more uncertain the future of the NHI becomes, and the more resources are diverted away from immediate healthcare needs. This is why the upcoming constitutional court hearings are so critical, because they will not only determine the legal standing of the policy, but also set the tone for how South Africa approaches large-scale reforms in the future, particularly in sectors where public interest, private stakeholders, and constitutional principles intersect. Ultimately, this is no longer just a policy discussion. It is a test of governance, a test of planning, and a test of whether the state can successfully navigate the complex intersection of law, politics, and public service delivery. Because if the NHI fails in court, the consequences will go far beyond healthcare. It will raise fundamental questions about how major policies are developed, implemented, and defended in South Africa, and whether the system is capable of delivering the kind of transformative change it promises.